I'm attorney Philip Ellison from the law firm of Outside Legal Counsel. I wanted to send you this quick video today to let you know about a major update that's just happened at the Michigan Supreme Court. As you may or may not know, there's been a lot of fights with the Roscommon County and Crawford County Board of Commissioners regarding the use of special assessment districts under what's known as Part 307. You've heard about the news, you've probably heard about the public meetings. My office, with the help of the and support of the Higgins Lake Property Owners Association and various property owners around the lake, have been challenging these county boards' attempt to create this funding mechanism, but it's coming out of the individual lakefront and lake adjacent property owners around Higgins Lake. What's important to understand is there's actually two court cases going on right now, not just one. The original case, which we call Case 1, started in September of 2023 when lawyers for Roscommon and Crawford counties argued to the local court that it should be allowed to create a special assessment district first, and that's what's important, first. And what a special assessment district is just a list of all the properties who should have to pay a special assessment tax. That hearing was held in September of 2023. I was there and argued on behalf of the Higgins Lake Property Owners Association and other property owners to say, hey, time out. Before we have to decide who should pay for a special assessment, we have to figure out what that project actually is. The local circuit court judge disagreed with me, and we appealed that to the Michigan Court of Appeals. The case has been pending for a long time at the Michigan Court of Appeals, and we just had oral arguments on it in August. Unfortunately, the Michigan Court of Appeals affirmed Judge Bennett's decision, allowing for this two-part process where we create the district or the list of payers first, and then allow the counties to figure out what project they want that list of payers to pay for later. We think that's contrary to the Michigan Constitution, and we think it's also contrary to Michigan law. In Michigan, when a special assessment district is created, it's our view and it's our belief that before we figure out who has to pay, you have to know what the project is and what it will cost. Because a special assessment is basically a targeted tax. Taxes have to be paid essentially equally by everyone, but a special assessment does not. What the Michigan courts have held is that, at least in our view, is that the special assessment process has to have a proportionality and an allotment connection that makes it fair and equitable for those who are asked to pay aren't paying for the benefits that everybody enjoys. Because if everybody enjoys those benefits, it should be paid for with a tax, not a special assessment. So far, the courts have disagreed with us. Now, what's interesting is just today we filed our application for leave to appeal, asking the Michigan Supreme Court to hear this case. And we're very excited by this development because right now, the Michigan Supreme Court, in the last about month, has decided to take a similar case involving special assessments for sidewalks out of the city of Birmingham. And they're asking similar questions as we're asking here. Who has to pay for those sidewalks? Or in this case, who has to pay for the Higgins Lake improvements when so many other people benefit from those developments and for those improvements? What's important is that the Michigan Supreme Court, through our case and as well as through this Birmingham case, will be asked to answer whether or not public bodies like counties or cities or municipalities can figure out the payer list first and figure out what the project is later, or do we have to define what that project is now so that when we decide to go forward with such a project, it's allocated equally and fairly among everybody who benefits? Now, this law is complicated. It's very technical. So some of the law that we're using is more than 100 years old in this respect. But just because of long-term length of these court decisions actually supports our side rather than the government side, because if this has been the law as it's always been for 100 years, why aren't local governments following it? And we think it's because lower courts are not requiring them to follow that, and that's contrary to what the Michigan Constitution and our Michigan law requires for governments. If governments want to raise funds for a special project, they can do it with their tax dollars that they have. But what they can't do is collect all the tax dollars and then also use special assessments as a backdoor tax to benefit everyone at the cost of a small handful, whether it's around Higgins Lake or around a property development in Birmingham. So in the end, we are proceeding forward with the case at the Michigan Supreme Court. We have very high hopes and expectations for it. The support of the Higgins Lake Property Owners Association has been critical and helpful to all this. Its member support has been critical and helpful for all this because once it's established that the government can make the list first and tell that list what they're paying later, it essentially creates a never-ending supply of funding, basically a never-ending slush fund, if you will, never-ending supply of money from their view, and we think that's wrong. In addition to all of this, that's really case one that we're talking about right there. Case two is also the case that we are also challenging many of these same questions with a second challenge that is currently before Judge Bennett in the Roscommon County Circuit Court. We're asking the court there, now that the list has been made and the tax rolls, meaning the amount that has to be paid for a particular project, which has been the improvements that have been made on Higgins Lake so far, needs to go through this particular review process to prove that the amount of money that the government is requiring is in fact constitutionally permissible. And we don't think it is. Those arguments are currently ongoing. Briefing has just started on that process, and we're going to be making very similar arguments to what we made before. So the question many ask is, what's the difference between case one and case two? Not a lot, really, at its core. We're really saying to courts and to the governments, you can't just have an open-ended check access to our checkbooks. There has to be a plan, there has to be a cost, and there has to be a limit to how many times that you can dip into our checkbooks to be able to pay for projects and improvements that you want the community or others to enjoy. If you don't have those guardrails, essentially what you've done is you've created a second taxing system that governments can abuse and use to increase what they call revenue and what the rest of us call taxes out of our own checkbooks. So in the end, we're excited today. We're continuing case one at the Michigan Supreme Court. Work continues on case two. But at the same time, is the real core goal in all of this is to make sure that governments don't view your checkbook as a never-ending supply of money for the projects that they want and that they desire to undertake. Again, I can't thank enough for the support and help of the members of the Higgins Lake Property Owners Association and the various property owners around Higgins Lake who've helped support in these legal cases that have been hard, complicated, and drawn out. And we're, at some level, we're writing the book right now on how these kinds of court cases need to be done because so few challenges have ever been made to the lake level special assessment law that's currently on the legal books in Michigan. And that's known as Part 307. With these court cases, we're going to establish that precedent going forward and to change the way that governments view property owners around Higgins Lake as it really should be as their partners as opposed to their pocketbooks. Anyway, again, check out our website. It's on our website at www.hlsad.com. That will take you to the website that will give you more information about the special assessment and the various cases that are there. But in the meantime, your continued support has been incredibly helpful and incredibly appreciated so that folks like me can go in and try to change and better the law to protect our rights as property owners here in Roscommon County. Thank you.